Good evening, everyone. I welcome everyone present here who are here to hear about corporate and commercial contract drafting from our esteemed speaker here. So, we have Advocate Pushkar Thakur. He is a managing partner at Corridor Legal and he has experience. He has worked at law firms. He has also worked in court practices as well as several MNCs. So basically, that makes him a perfect person to help us with contract drafting because his perspective will range through all the fields of law. So, thank you for being here, sir. Uh, Thank you for giving us your time. So, uh, please.
Thank you, Manyata, and thanks to Team LawSikho for giving me this opportunity. I think today should be a good session as contracts is something that has an exposure on all departments and on all folks across the scalar chain. So I'm looking forward to this discussion and let's see how many questions we get and how many answers we are able to actually solve today.
Yes, sir. Yes, I think that this is a very interesting topic here related to contract drafting, since this basically forms the basics of everything. So even I am very excited to learn a lot from you.
Looking forward.
Yes. All right. So let us begin. So our first question here is like, I'd like basically our viewers would like to know, our students would like to know that what are the importance of a precise contract drafting? How do you make sure that you're not leaving any loopholes while you're drafting any contracts? Because that is a very big problem here when young professionals are drafting contracts.
Okay, that's a good question, Manyata. Precise contract drafting is not the way forward or the preferred option. It should be the only option, in fact. So, first and foremost, a contract is nothing but a vehicle that an organization uses to reach its destination. Now, the vehicle's job is to A, make the organization reach its destination, and B, to do that in a seamless manner.
Hmm.
Now, a precise contract is an extremely important aspect and the precision thereof because when a contract is shared with a client or a service provider, it is not their legal teams which are going to work and are going to perform the obligations that are enshrined in a particular contract.
Yes.
It is the various departments, it is operations, it is finances, it is human resources, it is the risk teams which have to identify and evaluate the risks. So
Hmm.
any contract needs to be precisely drafted, should be communicative, simple, and explanatory with respect to the rights, liabilities, and the requirements that each party has to follow with respect to a particular contract. So, precision definitely is a key component in a contract and needs to be followed regardless of the nature of contract, be it a turnkey contract or a software as a service agreement or even a shareholder and share subscription agreement for that matter.
All right. So, sir, when you say that a contract, like the language should be simple, so do you mean that it's not necessary to use the legal jargon? Students are afraid of that I'm not able to write the legal jargon. What do you suggest about that?
So, in very simple terms, and quoting a French scientist and a philosopher here, Blaise Pascal, he had mentioned once that if I had more time, I would have written a shorter letter. So the whole aspect of nuances and introducing all the legal verbiage somewhat defeats the purpose of a contract because, like I mentioned, it is not the legal team which is going to run a contract. It is the ops, it's the finance, it's the human resources. It is the different third parties that, in fact, have to abide by the obligations, safe data protection, etc. So
Yes.
the contract, as simple as it should be, is the best way forward. Of course, there is some verbiage that we have to include in a particular contract. Say terms like notwithstanding, save as otherwise provided. These are legal, uh, dare I say, artillery that a lawyer has in order to make a contract fully protective towards its client. So these particular wordings, of course, can't be avoided, but wherever it is possible for a council to do so, they should make sure that the contract is as simple, summed up, and clearly enshrines and outlines the obligations of each of the parties.
All right, sir. So, what do you suggest that what are the few key elements in a well-drafted contract? What would make a contract well-drafted?
Okay, so your question here is what are the key elements of a well drafted contract?
Yes, sir.
So I will try to move a bit beyond the realms of the key elements of a contract, which are generally discussed at forums like this.
Mhm.
Now, before moving on to what the key elements of a contract are, I understand that we have a very large audience here. So I will
Yes,
want to quickly just explain what a contract is. A
definitely.
contract is, yeah, a contract is nothing but an agreement enforceable by law. Now, what is an agreement? So, simply put, and specifically in legal terms of the governing law, which is the Indian Contract Act of 1872, when a person signifies to another person his or her willingness to do or abstain from doing something in order to obtain the assent of the other person, it's a proposal. A proposal, when accepted, becomes a promise. A set of promises is an agreement. Now, coming back, an agreement enforceable by law is a contract. So, for an agreement to be enforceable by law and in order to become a contract per se, there are certain key elements. Now, your question is of a perfectly drafted contract. So, firstly, let me just cover up the key elements which law students specifically should know. The key elements are fairly simple here, Manyata. There should be two parties, firstly. Now, these two parties should be competent enough to contract. Now, what is competency? The two parties need cannot be of minor age, they cannot be of unsound mind, and of course there should be no law that expressly declares them as parties which are incompetent to contract. Firstly, secondly, these two parties have to make a valid offer and acceptance to each other with the intention of creating a legal relationship henceforth. So this particular element is extremely important, like it was in the case of Balfour versus Balfour. This is an extremely important element that there has to be an intention of creating a legal relationship. Now, coming to the softer aspects, of course, there has to be consideration between the parties. I cannot tell you today that in a contract you do X, Y, and Z for me and I do nothing in return.
Yes.
So there has to be a valid consideration. There has to be a valid object. It has to be a lawful object. The entire object as to why a contract is being entered into between two or more parties has to be extremely lawful. It cannot be void or go against the public policy, etc. Now, even the basic nuances of a contract, like say stamping, getting the documents signed in the proper manner, these are also certain key requirements of a valid legal contract. Now, of
Oh,
course, one thing that we have to focus on here is that the parties have to give their free consent, and just a consent is not a valid enough proposition here. So, what is free consent? Free consent is very simply put something that is free from any sort of coercion, any sort of undue influence, any sort of fraud, misrepresentation, or a mistake. So, if we take these five aspects together and see them in silos, coercion, undue influence, fraud, misrepresentation, and mistake are something that will lead to a party to not understand the ramifications and the obligations enshrined in a contract in the manner that they would want to be. Secondly, of course, the contract cannot be void as per law, so they cannot an agreement cannot be in restraint of trade, in restraint of legal proceedings, on in restraint of marital proceedings as well. So as long as these requirements are met, an agreement can be said to be a contract, and these are the key elements. Now, coming back to your point as to a perfectly drafted contract, we have to always understand that as lawyers, we are providing solutions to businesses. So, if you have a drafted contract which is meeting all those say key essentials of an agreement and a contract and is enforceable by law, that is toothless and immaterial till the time the intentions of the business, which is your client, is not clearly portrayed and the rights of your client are not clearly protected. So, and this is a horses for the courses situation, Manyata. Different agreements have different requirements. Say, for instance, since you're talking about well drafted agreements, let's pick up the common ones. Say, for instance, a shareholder and share subscription agreement. Everything can be legally valid and we can have a lawful consideration, object, competent parties, no coercion, undue influence, fraud, misrepresentation, mistake, nothing void therein. But we have to make sure that certain clauses say, for instance, right of first refusal, right of first offer, anti-dilution rights, and perhaps the clause that is discussed the most in investment agreements, that is the reserved matters. These contracts have to be drafted in a manner in which they are helping your client and making sure that whatever concerns, inhibitions, wants, and aspirations that your client has are clearly put forth. Similarly, for an employment agreement, which is an intra organization contract, we have to include specific clauses on non compete, non solicitation, confidentiality obligations, collection of personal information, post termination obligations. And these aspects are key to a particular contract. Now, giving you a final example, say, of a engineering procurement construction situation where there is a turnkey contract. Now, a construction gets finished in 3 years, 4 years, 5 years, but once we culminate the contract as well, and once the entire amount is paid, we can still impose a defect liability period in which the subcontractor or the contractor as applicable will be liable to rectify the defects that may be caused due to the poor workmanship or due to the poor quality of items that they have used. Now, this is an extremely important clause for a lot of constructors here in India as well as abroad. So, a drafted contract per se, which is enforceable as per law, has to, of course, meet the key elements which I just explained: two parties, competency, etc. But a well drafted contract, a lawyer will need to look into what the business wants, what it is afraid about, what are the showstoppers, and then include those specific provisions basis the specific nature of a particular contract. Even for a software as a service agreement, we have to make sure that uh, there are current and future provisions with respect to software maintenance. What are the licensing requirements, etc. So, a perfect combination of the legal aspects as well as the commercial aspects may, in my limited understanding, give you a perfectly drafted or a well drafted contract.
That was a beautifully put answer, sir. It basically cleared up the substantive part as well as the practical part of it. So when you say that an advocate should take care of all the requirements of the client and should put that in the contracts, but there are still some pitfalls that an advocate can come in front of. Like some pitfalls can come in front of an advocate. So what are these pitfalls that we should be aware of and how to avoid them?
See, at the end of the day, we can't step into the shoes of the business and take commercial decisions.
Yes.
But all legal fraternity talks about is creating value and adding value. How you as a lawyer are different from another M&A lawyer or a transactional or a operational contract lawyer. Now the value addition is in understanding the business. Say something like I just mentioned, the aspect of a DLP or a defect liability period. If a person is not well versed with construction agreements, turnkey EPC contracts, he may not even be able to assume or decipher or predict the requirement of such a clause. Similarly, for a software as a service or an SLA for that matter, the licensing requirements, the usage, the maintenance, and even for web-based agreements like terms of use, terms and conditions, what are the requirements that are there? What do the consumer protection e-commerce rules require? So before understanding the pitfalls, of course, the lawyer has to be well aware about the law. And to understand the pitfalls, that lawyer has to be totally engrossed in the business. The lawyer needs to understand that he is basically a catalyzer for the business and is, again, coming to my point one, is a vehicle that the business is using to achieve its end milestone and to reach its destination.
Yes.
So simple aspects, Manyata, just to sum it up, like payments, maintenance, obligations, transferable obligations here, something that we can transfer from our end to the other party, say the requirement of taking permissions, licenses, etc., which are sometimes extremely tough in contracts, especially in construction and real estate agreements. So if all these are taken care of, I think the pitfalls can very well be addressed by any practicing lawyer or a corporate counsel.
All right. So, in any contract drafting, basically, or contract management related work, negotiation becomes a very big part of it. So, how do you, in your experience, approach negotiation element of it, and how should our listeners approach to that?
So negotiations is a different ball game. As lawyers, we must understand that we are paid for only two things: what we write and what we speak. So
Yes.
negotiations, I can't run a negotiation before I know what my client really wants, right?
Hmm.
So it is up to me as a counsel to do quite a few things before I sit on the table with my client to understand their needs and what things are technically showstoppers for them and what things they can technically give a leeway to. So simple things like understanding what are the things that are completely dangerous risks, say I must say, or some risks can be avoidable, some risks can be transferred. So that is something that I we have to highlight to our clients as lawyers. And we also have to highlight the payment consideration, the different legalities that will be required, the compliances and the obligations thereof, and then get the view of the client as to where all it is willing to melt and where all it is willing to stand as a rock and say that, okay, this is something that is a complete non negotiable for me.
Hmm.
So once we have that artillery, we can enter that battlefield. And the second aspect that we as lawyers need to understand is that we are merely facilitating the contracts. So a lot of times I've seen investments having, say, a 5 CR to a 40 CR value having a similar set of reserved matters and a similar agreement from the same investor. So that should not be the case. So contract negotiation has quite a lot of precursors to it, clear identification of issues, the showstoppers, things that perhaps the client doesn't want to budge on, client is fine with. All these things need to be perfectly catered. One thing also that I would want to add here, Manyata, in a
Hmm.
lot of negotiations, what I see is that if there is a counter given to a particular lawyer with respect to a particular clause, they start defending it. So they either start defending it, saying that, hey, it's a non negotiable for me, or they say that, okay, it's a passable, we give you the green flag. But instead of doing this, what perhaps I can suggest to all the young lawyers out here is that you justify the rationale for inclusion of that clause in a particular contract so that the other party also understands why you are trying to per se include or exclude something from the provisions and how it perhaps benefits the other party as well. Say clear notice requirements. So this is something that the lawyers as a strategy can adopt, other than of course making sure that they identify all the risks and communicate and discuss and have a clear set of directions from their client and not of course go beyond them.
All right, all right. So to sum up what you said, you're basically saying that once we understand what our clients require, what are the deal breakers and what are the things that they're allowing us to pass. Once we understand that, the negotiation part becomes, easy for that matter because we know what our client wants.
Yeah, so see, it's any sort of contract, especially in a set of tougher negotiations where there is a lot of price escalation and requests in that regard. It's always a carrot and stick approach. With your client, you have to make 15 points and put them forth for acceptance, but you should know at the back end what are the 3 points that the client is just not willing to budge on, what are the 7 points that the client can budge on, and what are the 5 points that the client just does not care about
Hmm.
or is not a part of its commercial or future concerns. And then you have to approach a particular negotiation so that you know at the back end that, okay, these are the 3 or 4 points that are totally non negotiable. And in the discussions, perhaps you can strategize and try to accept from the other parties the points that the client really doesn't care about or are neither a commercial or a future concern for your client, and subtly put forth and have the clauses signed which your client thinks would be total showstoppers if they are not allowed.
Hmm. So the step one of negotiating is not to talk to the other party, but to talk to your own client basically first.
Definitely.
Yes. So, sir, basically, what I wanted to ask you was that there are a lot of templates available on basically the internet. We have so many templates of each and every type of contracts, and in the contracts as well, there are a lot of boilerplate, clauses. So, how do when I am drafting a contract, or maybe when the listeners are drafting a contract, how do they make a contract their own? How do they, uh, not let it be just a template?
Okay, so this answer is not specific to young lawyers. This one goes out to all the lawyers and all the folks who are interacting with these agreements, like say operations, human resources, finance, risk, and every other department, in fact. And I will break this down into two parts for you. Firstly, you spoke about the aspect of using templates, and the second aspect is the importance of boilerplate provisions, correct?
Yes, yes, sir.
So let's speak on templates first. As a matter of practice and as an exercise towards abundant caution, I will strongly suggest to all the lawyers out there not to use templates, at least in the first decade of their work experience. Every clause of a contract has an effect of its own. Every clause of a contract has a set of precedents underlying it. There are enough contracts in this country and there are enough cases before the judiciary for us to understand and ascertain that every clause that we are including in a particular contract, the legality, admissibility, enforceability, and the viability of which has already been decided by a court of law. So please don't use templates. Please, of course, you can always go through drafts. You can learn the tricks of the trade. There are lots of good articles by a lot of top law firms. You will get a lot of knowledge from the internet, but the internet is not where your contract should come from, especially in this day and age of Google. A contract should be drafted from scratch, should be specific to each and every requirement that your client has. And like I said, and like what perhaps scientist Blaise Pascal mentioned, if I had more time, I would have written you a shorter letter. So why draft a 44-page shareholders agreement when you can justify everything in 25 pages? And the point on that is a simple agreement on future equity safe, which a lot of players in America use. So it's a 5 pager which gives everything in such a perfectly summed up manner that begs us to question, why do we actually need 60 page, 70 page, 80, 120 pages investment documents here in India? So no templates is what I will suggest. Of course, it's subject to the discretion and convenience of all the folks out there. Use them as direction points, but draft your own contracts. And I'm sure that it will do wonders for you as well as your client. One more thing I would want to perhaps conclude this particular point with is that I've seen a lot of terms and conditions of websites being copied from other websites. Now, of course, there is a lot of text available online on these web based policies. But the ramification of this is that if a person uses a template from internet and gives that particular template to his or her client, the client might be happy for the interim, but the entire search engine optimization, the web results, the website performance of that particular client is going to go down because Google will delist or put these websites lower in the search rankings because their text is copied from other websites. So, with the intention of making some quick bucks, lawyers should not be trying to save their time, in fact, and giving their clients copy pasted agreements because they affect not only the commercial understanding but also the business growth and outreach, since copy text is downgraded by Google, which is the most important metric of a search engine optimization today in the world. And tech is the most important piece of growth for any organization. So templates are hurtful, stay away from them. And perhaps, of course, they can be used for knowledge gathering and to be tuned respectively for each of the requirements that each of the clients have, qua each of the contracts, of course.
Yes. So the next part was related to the boilerplate clauses.
Coming to the boilerplate, see, boilerplate provisions are like legs of a person who's trying to climb a mountain. You can't climb a mountain without legs. And contract drafting lawyers specifically need to understand that the business neither has the time, not the bandwidth, not the technical expertise to understand boilerplate provisions. In cases of disputes, especially in larger ones, these boilerplate provisions come to the glory, and technically they take the merit away or bring back the merit into a particular case because of their text. Simple aspects like that of requirement of a notice. So just for the audience here, boilerplate provisions are nothing but the beginning and ending basic provisions which govern the functioning of a particular contractual relationship, includes variation, severability, governing law, jurisdiction, notices, etc. So, and now coming back to my point, even aspects like notices, if a particular agreement mentions that a notice to a particular address will suffice, and that mentions that okay, the address mentioned above in the preamble, but unfortunately if that particular client is using its registered office address and is not checking the communications there regularly and has a operational corporate office in some other location, then it will be fatal for that client, because the other party will be clearly able to prove that okay, hey, this is the notice of variation or amendment or termination for that matter. We had sent them this and they had received it at the registered office. There is a particular receiving courier receipt, yala dala, and the case is proved. But practically for your client, they haven't received the notice because it's at some registered office, which is a residential, which is a residential place in a nearby uh, residential area. I'm sorry, I got a call. So, point here again is that even simple boilerplate provisions need to be looked into in a very careful and structured manner. They have to be again drafted with respect to the requirements of the client. If they have a corporate office, that needs to be mentioned. Governing law and jurisdiction again are two pain points which the clients face. Clients need to be aware as to where they can get the fastest recourse, what's the best dispute resolution forum for them, and all this can be decided only when we choose not to include ignore the boilerplate provisions. Now, just one example on that, Manyata. Around 3 years back, there were a lot of issues raised with respect to the COVID-19. Say if you are a supplier of goods and if there is no force majeure clause, or if that clause doesn't include a pandemic per se, and you were required to deliver certain goods by 29th of March 2020, and a lockdown was put on 21st or 24th of March, you are unable to supply those goods, then you will be liable even for termination, damages, penalties, and of course the products per se. But if there was a dispute, if there was a force majeure clause which is safeguarding your rights with respect to a force majeure event like a pandemic, and it mentions that neither party will be liable to each other for the performance of obligations thereof, then you can save your boat simply from with the help of a force majeure clause in a contract. So boilerplate provisions, again, one thing to be remembered here: every word in an agreement is a contract. Every word in the agreement should reflect what your client wants. So definitely no ignorance of boilerplate provisions, and definitely no usage of templates. After 10 years, when you know the legal ramifications of each of the clause, when you know what how a particular clause is going to play out in before a court, please go ahead. But for the first 10 years, I will suggest stick to your knowledge, try to create agreements, and these agreements, if you create, I can assure you, you don't need to do 50 transactions to become a expert in a particular type of contract. You need to do one contract 3 or 4 times. You need to know where the clauses will lead your client in the court at. You need to know how these clauses will be interpreted by a court of law, how protected your client is, so that you can best minimize the risks for your clients.
All right, sir. So now that we have talked about the boilerplate clauses, let's talk about the other end of the spectrum, the clauses that are, specified to each and every contract. For example, the risk mitigation clause or maybe the dispute resolution clause. All these clauses are, specified to every contract, and it is associated with the specific risks associated with the contract. So how do you approach them, and how should we approach them?
Okay, so I will take your discretion to again branch it out, because risk mitigation is a completely, can't say a different world, but a huge world of its own. And dispute resolution, of course, is a different ball game altogether. So I will speak firstly of risk mitigation. So risk mitigation, before coming to the question that how to draft risk mitigation clauses, even in an individualistic scenario. Manita, you there?
Yes, sir. Yes, I'm here.
Yeah. So coming to the risk mitigation, as to how to draft a risk mitigation clause, and even before coming to that scenario in a individual contract, we have to take a few steps to firstly identify what the risks are. We have to know what the risks are, and then only we can mitigate them, correct?
Hmm.
Secondly, we have to evaluate these risks. Now, I will, of course, press on these in a more detailed manner right now. Thirdly, you have to strategize what risks can be accepted, what can be avoided, what are showstoppers, what can be transferred. And then we have to draft the particular risk mitigation related clauses. So, what's the first step? First step is identifying the risk. Now, what's the risk that can accrue to an organization? Many people think that it's only financial, but there are quite a few types of risks which an organization can face and which can have far reaching consequences and bearings on a particular organization.
Hmm.
Say, for instance, coming to the basic forms of risk, one is a form of financial risk. If I'm entering into a contract, what is the credit risk that I have? What if the other party is not able to comply with its obligations in the contract? What if there is non-conformity with those basic stipulations, say with respect to insurance, a bank guarantee? What is the credit risk that is accruing on me as a client? Secondly, with financial risk only, I would like to mention another aspect of liquidity risk. Can I, as a client, make sure that I keep making the payments that are required to be paid apropos the contract, and ensure that there is no unforeseeable financial harm on my own organization? Am I financially well equipped to take that particular piece of contract and onboard a particular contractor for that purpose as well? So financial risk is something that is at the top of the game. Secondly, there is an aspect of reputational risk. Now, multinational organizations ball on reputation. It is one of the most important aspects, and why not? Because they have built it over centuries. If, say, I am undertaking a project for the construction of an office of a multinational telecommunication giant, and if my subcontractor messes up, A, of course, it's a delay. B, of course, it's a financial risk. But most importantly, it's a reputational risk in front of one of the largest telecom players. So, reputational risk, financial risk, which specifically focuses on credit and liquidity risks, security risks are there. How is the personal data being handled? How is the personal data being shared with the third parties? Do these third parties have the same level of conformity of data processing obligations? Do they have limited access? Do they have the relevant keys for handling and processing personal data? Are they in countries which comply with the same obligation? Do they have those contractual requirements? Say, if we are taking any data for the EU and the EU GDPR, we have to have records of processing. So, is a third party or the contractors, sub-agents are in compliance with these requirements? So, financial risks, reputational risks, security risks are all very important aspects that we need to take care of, and then we have to sit with the business, highlight the risks to them, and that's where a lawyer adds value. That's when you sit with the client and say that, okay, this is an insurance that they have just randomly mentioned, but this will have a cost implication of 500,000 USD on you. So are you willing to take that cost? So something has to be, of course, made sure here that we are identifying all the risks, assessing them. Quite a few risks can be transferred. Say, if I'm getting a property constructed by you, or say a 10-acre affordable housing society, and you are the developer, I'm the landowner, and you put all the compliances on me to get the requisite licenses, permissions, government approvals, environmental clearances, and all, then I'm in a soup because you are the builder. You know the tricks of the game. When I go to the authorities, I'll be dumbfounded. In fact,
Hmm.
so this is a transferable risk that a landowner can transfer on the developer, qua of course basis basic legal provisions and the applicable industry practices. And once we identify the risks, identify that okay, these risks we just cannot take, these risks we are just fine with, these risks just are okay, we are neither concerned nor too happy about them, then we draft the risk mitigation clauses. And these risk mitigation clauses per se just need to be extremely specific on the risk that they are mitigating, and they have to be comprehensive in their outreach. Even a dispute resolution clause, which is which can't really be said to be mitigating a risk, but for addressing a risk, also needs to specifically mention that okay, it covers all and any matters incidental to or arising out of the agreement, because not all matters are arising from the agreement itself. There are quite a few matters which are in connection therewith. So a simple set of these three words will save crores for your clients before a regulatory or a dispute resolution mechanism.
Hmm. All right. Thank you. So, okay, so let's talk about another set of, clauses. What are basically the considerations and the consideration clauses in the mergers and acquisition and joint ventures agreement?
Mergers, acquisitions, and joint venture agreements.
Yes.
So uh, again, these are completely different ball games. So merger is a different ball game. A vertical, horizontal, conglomerate merger, or different types of mergers, or an acquisition, be it by way of a acqui-hire or a business transfer or a slum sale or a JV for that matter, be it an SPV, a special purpose vehicle, or otherwise. They're completely different ball games, but there are specific things which are common and standard in all these transactions,
Hmm.
specifically for acquisitions and JVs, definitely. So first thing that we have to, and consideration as such is a wide term because there are a lot of considerations which are beyond the reins and powers of the legal department or the lawyer per se. So I will not be going into the financial and the viability considerations because this is something for the business to understand, analyze, and then give it to us for our filtering. But simple aspects like what are the legal and regulatory consideration that is there when it comes to undertaking a particular type of transaction.
Hmm.
Am I legally allowed to do that? What is the reporting that I will have to make, and who do I have to report it to? What is the time frame in which I have to do that? If I'm acquiring shares, if a foreign party is acquiring shares, what is the time frame for reporting of the FDI? When is the FDI going to be reported? When is the consideration going to flow? Is it before the transfer of shares or after the transfer of shares? If it is tranche based, then what are the compliances that I will have to take on a rolling basis? If I'm taking, say, a construction, completely different world from investments, right? A construction, an SPV for a construction of a metro rail project, say in the state of Delhi, NCR. There we have to see what are the permissions that are required. What happens if, say, in a situation where a land use is being changed, where the government is acquiring it? How do we deal with the government? What are the key considerations that I have to be aware of and communicate to my client that okay, hey, these are the red flags, these are the doable ones, these are a no-brainer. This is something that we must highlight and we must not budge on. Aspects like these are, say, the key legal consideration. Now, there are operational considerations as well, which a lawyer has to look into. Say, if it's a simple acqui hire, you hire the employees to the entity. How are the employment contracts framed? What about the ESOPs? What about salary revision? Simpler aspects like what about the trademark? What about the designs? What about the trademark rights that we have given to third parties? What if we want to curtail that post the acqui hire or the business transfer for that matter? So operational considerations are there. Legal considerations are definitely there, and the bigger ones, of course, being the regulatory ones. Now, payment considerations is something that I would want to talk about here. Payment considerations, we have to make sure that whatever payment is to be made, qua the transfer of shares slash acquisition, the timing of the same, the mode and modality of the same. Is there any escrow required? What is the requirement of the escrow? In what situations can the escrow be, say, addressed? These aspects also have to be taken care of. So, of course, your legal, your operational, your financial, and lastly, since we dabble a lot with corporate compliances, there are accounting obligations as well, which an organization and lawyers working in conjunction with chartered accountants, of course, need to be extremely aware of. Say, I'm investing, I'm investing a CR in your startup, Manyata, and I'm taking 10% equity. You are very happy, you give me that equity, and we culminate the transaction. But where is the report from the merchant banker slash registered valuer as applicable? So something which is a legal sine qua non for an agreement, for a transaction like this to be legally enforceable and avoid any sort of penalties and legal actions from the authorities. So all these aspects need to be taken care of, and I think these are the main considerations that you will want to take care of: the legal, operational, financial, and of course the accounting ones, which are quite tough and they keep changing on a Y on Y basis.
Yes, yes. So, talking about the regulatory compliances and the considerations that you were talking about. So, I understand that with experience, you know what all compliances you have to make sure. But how do a new lawyer does that? How can we do that? How can we make how can we ensure that our contracts are regularly compliant?
So it depends on the kind of industry that a particular lawyer is servicing as well. Say, I will take an example of a very basic clause which all lawyers know across the boundary and in all years of law school as well, which is a simple arbitration clause.
Hmm.
Now, a layman might think that, okay, arbitration clause is governed by the Arbitration and Conciliation Act, but it also has an interplay of the Code of Civil Procedure because of the interim relief, etc., that can be given, correct? Then there is Indian Contract Act also because eventually the contract is being governed by the Indian Contract Act. Competency is being governed by the Indian Contract Act. So point here is that the starting step, of course, should be to get back to the books, to research as thoroughly as possible. This is the place where a person can take help from templates and use cases in the industry, understand what are the clauses that will be required. In addition to this, the person has to clearly and effectively communicate with the client, ask them what their concerns are, put those clauses in the contract with respect to the regulations, etc., as well. But make sure at the back end that these are enforceable. So today, if I invest in your company and say that tomorrow you will have no right to take any legal case against me or proceeding against me, perhaps my client as an investor will be very happy, but and as an investor you might be sad, but eventually it's not going to pass the muster of law. So what's the rationale behind putting a clause which doesn't pass the muster of law because it's an agreement clearly in restraint of legal proceedings?
Legal procedure.
So legal knowledge, of course, is of utmost importance. Going through the draft, having that knowledge, conveying your client's concerns in the most kosher manner. And if you know your client's concerns, you can very well redline a contract that comes from an investor as well, because you will be knowing that what all aspects have just not been communicated or agreed to, perhaps by way of a term sheet.
Hmm. Yes. So you use the word red line. So just give me a brief about it. How do you review, contracts? How do contract review works?
So, see, contract review again, once you are very thorough with what the client wants, everything becomes easy. The drafting becomes easy, negotiation becomes easy, review vetting also becomes easy. Because you know what the client wants, what things the client is just not willing to budge on, right?
Hmm.
Now, contract review, first thing that I will check, especially for young lawyers out there, there is a benefit that older lawyers have, and that is that they have worked more hours on a particular piece of law. So, first suggestion is, of course, to get a four-eye check on your document. It doesn't hurt to ask your senior associate or your partner for 10-15 minutes. Your partner should also be kind and kosher enough to give you time, because eventually the client's work is the most important aspect in a particular law firm or a legal practice. Get that 4i check, lock your horns with your senior. Don't be afraid of coming out and saying that, okay, I think this is this because of this particular requirement. Say section 19 of the Sexual Harassment of Women Prevention Prohibition Redressal Act 2013 requires the publishing of a penal consequences notice and the board resolution, which you are saying as a confidential document, but the law requires it. Am I correct? Am I incorrect? So lock your horns. Uh, then have a review, and of course it's all a part of the 4i check. Secondly, on the aspect of review, I will just again want to reiterate, guys, every word of a contract is a contract. A notwithstanding or a save as in or a shall or a may or can and could will have a huge implication of the on the contract. And these are the things which all the which differentiates in fact all the top lawyers from the average and no show lawyers in this country and abroad. So be specific on each term of the contract. No term of the contract should be alien to either of the parties. If if say there are no prior agreements or understandings in writing, don't put in your agreement that this supersedes all the prior agreements, because it's totally redundant. But if in an employment relationship you are taking Aadhaar of an employee, which I can assure you it is applicable for 100% of companies in India, because Aadhaar collection is a part of requirement of Forms 11 and 13 under the Employee Provident Fund provisions. Put the respective clauses for informed consent on Aadhaar collection in employment agreements, because it is a legal requirement. Uh, I can ask you, Manita, how many contracts have you seen with a Aadhaar collection requirement in an employment agreement?
Sir, I haven't seen. I have signed one,
Exactly.
but
And
I
this is a
haven't
legal
seen.
requirement. Yeah, exactly. So this is a legal requirement. So a contract is nothing but putting forth what you have understood and agreed to in a legal language, and law is nothing but codified common sense. You don't need to be a rocket scientist to be a good lawyer. Be diligent, read the law, know that every word has its effects, and then draft your contracts and review them accordingly. I think any lawyer should be good to go if they follow the simple standards of drafting and contract negotiations slash review.
Hmm, that was a great tip from you, sir. So, just to sum it all up, and just speaking from your experience, just give some few practical tips to all the young minds here about contract drafting. Just some practical tips. Although you have explained a lot and it has been a extremely insightful session, but still, just to sum it all up.
Yeah, I can tell you there are a lot of lawyers are coming from non-NLUs,
Hmm.
and a lot of them are coming from national law universities. It is somewhat of an unwritten understood fact that people from national law universities have a edge when it comes to employment.
Hmm.
But it's all about making your resume different from the other person's resume and showing how you are adding that individualistic value to a particular job requirement. Now, I might be the best rocket scientist of this world, but if the job is of a gardener, a person should choose a gardener who's better than me. So there are a lot of courses out there which a person can take, learn from. sec.gov.in has thousands of drafts which the young lawyers can read, understand, interpret. You don't need a multi-million dollar client to do multi-million dollar work. Even the Reliance future issue that was there in the comment as a part of the post, you don't need to be a part of the teams repping both or either of these, say, parties at dispute or involved in that for that matter. You just need to open the news. You need to understand and see where all law is being applied. How is the law being interpreted by a court of law? Till as long as say 2019, unilateral appointment of arbitrator was fine. Every real estate player used to appoint its arbitrator in a case against its own. But now it's a settled law. But I see so many arbitration clauses coming still with unilaterally appointed arbitrators. Okay, you are making your client happy, but eventually he is going to hate you, because when it goes to a court of law, the court is going to say, hey, no unilateral appointment. Section 11 petition, there is no agreement on appointment. Approach the Honorable High Court of the particular state, get the arbitrator appointed through the process of court, and pay that particular amount to your lawyer. So eventually, the client is losing out on money, and something that the lawyer should be extremely wary of, because eventually it's all a commerce.
It's all corporate and commercial. That's what the
Exactly,
topic for the show is.
exactly.
Yes. So thank you so much, sir, for this answer, and for being available here, from taking out your time. I know you are extremely busy being the managing partner and everything you all do. So thank you so much for being here. It was a very insightful session for me, and I understand that for each and every listener here, you have been so clear with every answer that you have given, and you have like not just tried to so you have not given any surface answers. So we are really glad that you were here, and thank you so much for being
Equally my pleasure, Manita. And thanks for everyone. Thanks to everyone for joining this.
here. Yes. So thank you all listeners, whoever are here. I hope the session was insightful to you all. And all right, bye.
Thanks, guys.
Thank you so much, sir.
Thank you.